May it please your lordship. Your lordship, I beg to mention item number 5, your lordship. I am praying for 1 week's time in this matter, your lordship. We are awaiting some instruction from our client, my lord. Item number 5.
On the prayer of Mr.
A. Das, my lord.
A. Das, learned counsel for the great petitioner, this matter stands adjourned for a week. List again for motion in the next week.
Obliged.
May I please your lordship, item number 33 and 34 maybe come up after a week. Because
Sorry,
some
item number 33 and 34?
34, my lord.
Yes.
Some personal difficulties is there, so matter maybe come up.
But this has been listed on mention
My lord.
by order then. Who has mentioned?
Mrs. S.B. Chaudhary has mentioned and she has some personal difficulties. my lord.
Well, you mention a matter and then on the prayer of learned counsel for the petitioner, this matter stands adjourned for 3 weeks. List accordingly. Same order in 33 and 33.
Obliged.
Item 13 and 14, my lord.
Yes.
We have filed one IA, my lord. So it is not tagged. So can you requisition this matter? IA, my lord. Okay.
IA cannot be, then IA has to be listed.
Not yet listed. Not
Then
listed,
it will
but
have
we
to be
have,
posted on some other day.
yes, or
You are appearing for whom?
for the petitioner, my lord.
Then we'll direct the matter to be listed in the next
Yes.
week along with the IA. Yes or no? Then you wait
I am.
when the matter is called up. You wait when the matter is called up.
I'm in that case, matter, I'm for response.
Okay, let the matters be called up, then we'll pass an order. Yes.
My lord, with the consent of other party, I beg to mention item number 41, my lord.
Item number 41.
41. In this case, I prepared and forwarded the affidavit in opposition to the concerned authority. But 4 weeks time may be
On
granted.
prayer of Mr. A.K. Dattal and its CGC appearing for the respondent numbers 1 to 7, made with the consent of the other side. This matter stands adjourned for 4 weeks so as to enable him to file counter affidavit.
I'm appearing for the petitioner in this case. None of the interim order is there in this matter, so it
On the prayer of Mr. Afridi, learned counsel for the petitioner, interim order passed earlier to continue until further orders.
4 weeks.
May I please your lordship. In I request item of 10 lordship. The IA I want to withdraw with liberty lordship.
Withdraw with liberty.
IA lordship. That is implemental party we have just typical error lordship. So I want to withdraw at a fresh.
Okay, Mr. R. Sharma, learned counsel for the applicant submits that there is some error in the application filed in IA Civil 909/2025. Therefore, he seeks leave of this court to withdraw the IA with liberty to file afresh. Prayer allowed. IA stands disposed of on withdrawal with liberty as prayed for.
Wait, please, your
Let
lordship.
the connected contempt cases be listed after the IA is filed again.
Wait, please, your lordship. Lordship, beg to mention item number 43, my lords. 43,
Yes.
my lords, for withdrawal, my lord. I may be permitted to withdraw this matter. 43, my lord. It was
Withdraw.
transfer and posting is already superannuated, my lord. It turned infructuous, my lord.
Mr. J. Singh, learned counsel appearing for the writ petitioner submits that during the pendency of this petition, the writ petitioner has already retired from service on attaining the age of superannuation, and therefore the writ petition has become infructuous. Mr. I.
reasons.
Botagu, learned standing counsel, Forest Department, Assam, is present on behalf of the respondents. On the request of the petitioner's counsel, this writ petition stands disposed of as infructuous.
Obliged, my lord.
May I please your lordship? I am praying for the inclusion of a WPC, your lordship, in which I have a filing number, WPC number 5119 of 2025, your lordship. The urgency is that, your lordship, he has been asked to retire on superannuation on day after tomorrow, 30th April 2005, your lordship. Whereas his date of birth is 11/4/1969. With effect of with the strength of that lordship, he should get retired in 2019. 2029, your lordship, pardon me, your lordship. So, may it be listed today at the end of the list or maybe tomorrow, your
No,
lordship?
we'll have it day after tomorrow, but you can't get us interim order to continue. That law is very well settled.
Lordship, maybe tomorrow, your
No,
lordship.
no, you will be day after tomorrow, but you come prepared so that you know why the interim order is not granted. He cannot continue beyond 30th. At this stage, merely on the claim that his date of birth is wrongly recorded.
Yes,
There are a number of judgments, you read those and come.
Wrongly recorded one of the document, your lordship, otherwise in all the service documents, his date of birth is correct, your lordship. Only in one,
No, what is recorded in service book?
the correct one, your lordship. The 1969, your lordship. Only
Then-
in PF account is this
Then
date
the
of birth.
service book date will apply.
Yes, but he has been asked to get retired on superannuation on day after tomorrow, your
All
lordship.
right, all right, tomorrow.
Tomorrow, deeply obliged, your lordship.
Yeah, Lordship. Lordship, I beg to mention item number 29, my lord.
Item
I
number
have-
29.
29. I have taken the consent from the other side, my lord. This matter may be taken after 2 weeks, my lord.
On the prayer of learned counsel for the writ petitioner made with the consent of the other side, this matter stands adjourned for 2 weeks.
My lord.
May I please, your lordship. Lordship, prayer for listing of an IA lordship for modification of order lordship passed by this court lordship. It was last listed on another court lordship on 5th 12. Lordship may allow on any date lordship this week.
Day after tomorrow.
Obliged.
Lordship, with the consent from the other side, I beg to mention item 11 of the daily list.
Hmm.
Lordship, my senior Mr. P. Nayak is out of station. Lordship, may I kindly take up the matter after 2 weeks?
11, it's a partner matter.
Yes, Lordship.
Who is appearing for the,
I'm appearing for the petition.
what do you have to say?
Lord, he called me yesterday, but he's out of station.
A prayer for adjournment has been made in this case on the ground that Mr. P. Nayak, learned counsel appearing for the official respondents, is out of station and therefore is unable to attend the court proceeding today. Since the prayer is made with the consent of the writ petitioner's counsel, same stands allowed. This case again for admission after 2 weeks.
Lord, may I pray for 6th of May, my lord, if possible. 6th of
After 2 weeks, let's see, because
my lord,
the availability of the bench is also an issue.
my lord.
6th of May, this bench will not be available.
Fine, my lord. No issue, no issue.
Much
My-
obliged.
May I please, I beg to mention for listing on admission matter, my lord.
Listing of, why didn't you
petition,
speak in
my
the
lord.
microphone?
Matter relating to my lord. After inquiry, my lord, the matter placed before the chief minister for transfer, my lord. But
No, you want listing for motion,
no, my lord.
then
Actually, my lord, it will come at hearing matter, my lord, hearing column. my lord.
you have to make that mention. You request the registry, they will do it.
Obliged.
Yes.
My lord, I am praying for listing a writ petition for a motion. My lord, the matter is a condonation of us to participate in a selection process for the post of assistant professor, State Engineering College. And the last date of application process is on 8/5/25. And also the matter maybe, I am praying for listing this matter.
Friday?
Hello?
Friday, 2nd, 2/5. Huh? Maybe bench 2, before appropriate bench. 2nd May before appropriate bench.
May it please your lordship. Lordship, I beg to mention item number 12 of the daily list, your lordship. Lordship, senior counsel K. N. Chaudhary is currently out of station, your lordship. We have taken the consent of the other side. Lordship may kindly adjourn the matter.
On the prayer of learned counsel appearing for the writ petitioner made with the consent of the other side, admission hearing of this case stands adjourned for 2 weeks. Please accordingly. Yes.
Much obliged.
May it please your lordship. Lordship, the petitioners are Honorary Gauura in the district to breed Assam and has been working since for the past approximately for the past 20 years, Lordship. Lordship, on 10th of January 2000, Lordship, the Commissioner and Secretary, Revenue Department had communicated to the Deputy Commissioners that they had appointed one Honorary Gauura in each district of Assam, except the Hills districts, Lordship, for the purpose of bringing existence of Gauras in the state, Lordship. On 11th of August 2006, Lordship, DC had made a communication for need of Gauras in the district Dhubri, Lordship. Selection or appointment was not carried forward properly, so number of Gauras were not appointed properly at that point of time, Lordship. Petitioners, though they were selected and appointed as Gauras, Lordship, by the Gram Pradhan and accepted by the DC's, Lordship, they were working as honorary Gauras till date, Lordship. Lordship, many proceedings were initiated, Lordship. First, an PIL was filed before this honorable court to direct the DC to advertise the post of Gauura Lordship. And another writ petition was formed after that Lordship for direction to the respondents to initiate the process of Gauura. And an order was passed by this Honorable Court Lordship on 13th of March 2015, directing all the deceased to initiate the advertisement for the post of Gauura Lordship. Lordship on 10th of April 2018, Lordship. Lordship may be pleased to come to page number.
So what is
Page.
the main relief you are seeking?
Main relief is Lordship. They are working as honorary Gauburas. Now an advertisement has been issued.
Now
stating-
means when?
Lordship in the year 2018, Lordship. But
So it is not now. It is
this Lordship and Lordship
7 years back.
yes, Lordship, but and writ petition was filed at that point of time.
Mm.
And in the year 2023, Lordship, and an advertisement was was issued in accordance with the order passed by this honorable court as per the writ petition filed after 2018, Lordship, stating that remuneration may be given, Lordship, but no weightage shall be given, Lordship, to these Gaupuras.
That's all right.
I'm
So
challenging that,
right
Lordship.
now, we'll issue notice, ask them to respond.
Yes, Lordship.
Nothing beyond that.
Yes, Lordship, notice may be issued and they may be allowed to file an affidavit stating the current position, Lordship.
She's been very, very liberal, huh? Only notice. I thought you will ask for an interim order. You
At
don't,
this point of time, Lordship,
you don't want.
I want an interim, but Lordship,
But
they stand,
you don't think it is proper to ask for an interim order. is it?
Lordship,
No, you're right, you're right. You're right. Let us see what they,
yes, Lordship, because their stand is required, Lordship.
okay. देखो,
This is 1, 1, 2, 3. 1, 2, 3. I mean 4, 5, 6.
heard Ms. R. Barua, learned counsel appearing for the writ petitioners, also heard Mr. J. Hendik, learned standing counsel for the revenue
1, 2, 3.
department, that is the respondent numbers 1, 2, and 3. And Mr. A. Chakravarti, learned G.
4, 5, and 6.
appearing for the respondent numbers 4, 5, and 6. The petitioners hearing claim to be working as honorary Gauburas agreed due to non-regularization of their service and also the advertisement notice dated 6/7/2018 issued by the authorities for filling up the post of Gaubura on regular basis. An instant writ petition has been filed seeking a writ of mandamus. Mr. Hendik as well as Mr. Chakravarti have prayed for some time to obtain instruction in the matter. Issue notice returnable in 6 weeks. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers be furnished to the learned departmental council. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. The respondents may bring their stand on record by filing affidavit in the meantime. In the meantime, the respondents may bring their stand by filing affidavit. Right?
Herein the petitioner is an unmarried daughter of one P.B. Subramaniam, Lordship. He served as a junior engineer in the Public Works Department, Bokajan Development, Lordship. Now, Lordship, her mother received pension, Lordship, after the death of her father. Now, she is not receiving, Lordship, although, Lordship, she placed a representation before the Accountant General, Lordship.
Yes, but there is an order of 3rd June 2024.
Lordship, I was required to
You are
give some additional documents, Lordship. Herein, Lordship will kindly turn to page 23 once, Lordship. This is a
No, so what is to be done today? The
Lordship,
court says file additional affidavit. You don't want to file.
Lordship, because I have been told that the house was burnt twice, Lordship, and the documents she had is not there with her. Although she approached the Treasury Officer, Lordship, one half of the PQ is with the Treasury Officer, Lordship. That the Treasury Officer told her that she would not be given that any document, Lordship. But then, if the AG asks for the document, then it will be furnished, Lordship. It's at page
So
23.
what is
Lordship.
the petitioner seeking?
It's family pension, Lordship.
Then we'll issue notice and see how it
Lordship.
goes. Mr. MP Sharma, learned counsel for the writ petitioner. Peruse the averments made in the writ petition. The late father of the petitioner, the deceased father of the petitioner, was an employee of the government of Assam. First up, the petitioner had, after the demise of her father, the petitioner had sought family pension. However, since the request for family pension, for payment of family pension was not acted upon, the instant writ petition has been filed. By the order dated 3/6/2024, the petitioner was granted time to file an additional affidavit, bringing on record certain documents. Today, when the matter is called up, Mr. Sharma submits that since the house of the petitioner was burned down, hence no further document is available for filing before this court. First up. Situated thus, this court is left with no option but to examine the matter on the basis of documents available on record. Full stop. Issue notice returnable in 6 weeks. Who is appearing for whom? Who is for 1?
Lordship, P Nayak for 1 and 3.
But he is not in Guwahati today.
Your Lordship, I'm appearing on his behalf.
Achha. Miss
A. Bothakur.
Miss A. Bothakur, learned counsel, representing Mr. P. Nayak, learned standing counsel, PWD, Assam, appears and accepts notice for respondent number 1, Miss Kemprai. S. Kemprai, learned standing counsel, KAC for respondent number 2. Achha, it 1 and 3, huh, Mr. And Miss, who is for the Accountant General? And Mr. R.K. Talukdar, learned standing counsel for the office of AG Assam for respondent number 4. As such, service of notice is complete in this case. Extra copies of the writ petition requisited numbers be furnished to the learned departmental counsel so as to enable them to obtain instruction. This is the matter recorded.
Obliged.
May it please your Lordship. Lordship, on 2nd of April, the Government of Assam Health Department has issued an advertisement for regular appointment of different medical services. So I may be allowed to withdraw this petition with a liberty to file.
Ms. M.D. Bora, learned counsel for the writ petitioner, has produced a copy of the advertisement notice dated 2/4/2025 issued by the Secretary to the Government of Assam Medical and Health, Secretary to the Medical and Health Recruitment Board Assam, issuing for regular recruitment in the post of
Demonstrator
demonstrator in the government medical college hospitals, and submits that in view of the aforesaid advertisement, the petitioner be permitted to withdraw this writ petition with liberty to participate in the recruitment process. Mr. D.P. Bora, learned standing counsel, Health Department, submits that subject to fulfilling the eligibility conditions laid down in the advertisement, he would have no objection if the prayer of the petitioner is granted by this court. In view of the above, this writ petition stands disposed of on withdrawal with liberty to the petitioner to apply for the post of demonstrator in terms of advertisement dated 2/4/2025, subject to fulfilling the eligibility condition.
I'm so deeply obliged, my lord.
Yes.
My lord, in this case, actually, they are supposed to bring updated instruction. In this case, my lord, my specific case is that, my lord, the respondent, my private respondent belongs to a political party. And to that effect, we have, my lord, annexed a document also. He is not even eligible for appointment also, my lord, not to speak of his selection. But they have been selected, but he has been selected, my lord, in this case, as a Gauura.
In this count, Lordship,
we made an inquiry, Lordship. And in the inquiry, it reveals that he is not associated with any political party, Lordship.
Now, Lordship may kindly say page 46, my lord, in that case.
Page 46.
46, Lordship. Annex 13.
Yes.
You start from page 44, Lordship, but 46 is prominent, my. Now, Lordship will find this membership certificate. And selection was made thereafter. Selection was made thereafter, my lord.
This is the online membership, missed call membership, Lordship.
No,
And
then, my lord,
after Lordship, after verification of the membership, Lordship, it appears that he is the active member of that political party. Our submission is that he must not be the active member of any political party, Lordship.
Then, my lord,
Where
may
is the
look
advertisement
page
clause?
44.
No,
Lordship,
no,
may kindly-
clause in the advertisement.
Lordship will find, it is already in the executive instruction also, my lord. Nevertheless, that is there in the, Lordship may kindly say, page, my lord, page 20, my lord, that is type copy. There, 1, 2, 3, 4, my lord will see.
Hmm. Yes.
Clause sub. Any active, non-active, whatever it is not there mentioned.
So far, Lordship,
Yeah,
in our report, Lordship,
Hmm.
an inquiry was conducted by so-and-so order dated 17/1/2025 in connection with the petition submitted by Sri Haren Tati, in which he stated that the candidates selected for appointment of Gaon Pradhan against Hojur Tiok Gaon is an active member of BJP. But in the report submitted by the inquiry officer, it was concluded that the concerned candidate selected for appointment of the Gaon Pradhans against Hojur Tiok Gaon is not a member of BJP as claimed by the petitioner, Lordship.
Then
It is
page
out
44.
my report,
Lordship may
Lordship.
look page 44 then. Page 44.
All right, then we have to issue notice. Let
Yes,
him
yes,
come.
my lord.
Let him come. Take down now. Now, Mr. B.J. Bose, learned counsel appearing for the writ petitioner, peruse the amendments made in the writ petition. By filing this petition, the selection and appointment of the respondent number 5 as Gaon Pradhan of
Hojur.
Bhojotiok,
Hojur Tiok.
Hojur Tiok.
Bhojotiok Gaon in the district of Charaido, Assam, has been called into question on the ground that being a member of a political party, the respondent number 5 was ineligible
Yes.
to participate in the recruitment process as per clause 7 of the standing executive instruction
Yes.
laid down in advertisement notice dated 12/9/2024. In support of the above contention, the writ petitioner has brought on record certain documentary evidence to show that the petitioner, the respondent number 5, is a member of a political party, was a member of a political party at the time of submission of his application. First time. Mr. J.K. Goswami, learned additional senior government advocate Assam, submits that as per the preliminary inquiry made by the official departmental authority, the allegation made in the writ petition was found to be incorrect. Full stop. Mr. Ghosh, learned counsel for the writ petitioner, however, submits that on the face of documentary evidence establishing the plea of the petitioner, the respondents be directed to file affidavit. Full stop. In view of the above, issue notice of motion returnable in 4 weeks since Mr. J. Hendick, learned standing counsel for Revenue and Disaster Management Department, Government of Assam, has appeared and accepted notice for respondent number 1, and Mr. J.K. Goswami, learned additional senior government advocate Assam for respondent numbers 2, 3, and 4. Service of notice on the respondent numbers 1 to 4 is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the said furnished to the learned departmental counsel so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 5 by registered post with AD heard on the prayer of interim relief. The said prayer will be considered after completion of service of notice upon the private. respondent.
Obliged.
Return forward.
May I please, Lordship? In this
Yes.
case, my lord, notice has already been issued, my lord, by order dated, my lord, 28/3/2025, my lord. And accordingly steps taken, my lord, with the- My lord, it should come on admission column by.
Notice has not been issued.
Yes, my lord, notice issued, my lord.
Which order notice has been?
No, sorry, my lord, sorry, my lord, yes, on instruction. was
Notice not issued.
called. Yes, my lord.
Only for instruction. Instruction is awaited, my lord, 10 days time has been sought by the officer concerned.
Let's, in the meantime, notice may be issued, my lord.
Heard Mr. A. Hussain and counsel for the Muhammad A. Hussain and counsel appearing for the petitioner. Also heard Mr. S. R. Rabal and standing counsel BTC appearing for the respondent numbers 1, 3, 4, 5, 6, and 7, who submits that in terms of the order dated 28/3/2025 passed by this court, instructions as called for are still awaited. First up, I have perused the amendments made in the writ petition and have also gone through and have also considered the submissions made at the bar. The controversy involved in this writ petition pertains to appointment of Anganwadi
Helper, my lord.
and helper
Yes.
in 644 number Hututi Anganwadi Center. Full stop. In view of the submission made by Mr. Rabha, this matter, in view of the submission made by Mr. Rabha, issue notice of motion returnable in 3 weeks. Since Mr. Rabha has accepted notice for respondent numbers 1, 3, 4, 5, 6, and 7, and Mr. P.C. Kutia, learned.
6, 7, 6, 5 and 6.
You are for 2, 5, and 6.
Yeah.
Acha, then you are for Mr. T.C. Kutia, learned additional senior government advocate Assam, has appeared and accepted notice for respondent numbers 2, 5, and 6, and Mr. S.R. Rabha, learned standing counsel BTC for respondent numbers 1, 3, 4, and 7. Service of notice upon the said respondents is deemed to be complete in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned department counsel so as to enable them to obtain instruction. Let the matter be listed for admission again after 3 weeks.
My lord, pendency shall not be barred.
For
Pendency shall not be barred.
pendency of the writ petition shall not be a bar for the respondents to redress the grievance of the petitioner in accordance with law if so advised.
Obliged.
May I please, your lordship. My lord, here in this case, lordship, petitioner was serving as an assistant superintendent in the Artroy Sheva lordship. Thereafter on 6/10/2023 lordship, he was arrested, and on 9/10/2023 he was suspended lordship from the service. But as per lordship requirement of law lordship, as per Ajay Kumar Chaudhary as well as division bench, that suspension order was not reviewed within the period of 90 days lordship. And he is continuously under suspension lordship without reviewing the matter lordship. So
Yes, who is appearing for? Mr. Chutia,
Mr. Chutia is appearing lordship.
your name is shown in the order. You accepted the brief of the AACB?
Suspension was not reviewed.
Oh, this one.
Yes.
Oh,
This
yes,
one.
yes, my lord, the second show was issued. Anything in the inquiry report. That is the stage now.
No,
Inquiry
Where is
completed.
the written instruction?
Inquiry completed, my lord. Today I missed the file, my lord.
We'll have it next week.
Next, my lord.
Let him obtain instruction.
Friday.
My lord, this specific, my lord, whether that that inquiry report may be submitted or they may taken any action. But Lordship, the fact is that whether that order was reviewed or not, Lordship, that instruction.
That
may-
is, inquiry has completed, what is the need of review?
Heard Mr. N.H. Borvia, learned counsel for the petitioner. Also heard Mr. T.C. Chukia, learned standing counsel ACB, appearing for the respondent numbers 1 and 2. The plea raised in the writ petition pertains to alleged failure on the part of the departmental authorities to review the order of suspension of the petitioner before the expiry of 90 days. First up, Mr. Chutia submits that the inquiry has already been completed against the petitioner and the second show cause notice has also been issued. However, urging that due to oversight, he has missed the matter today. Mr. Chutia seeks posting of this case again on 6/5/2025 as a fixed item for motion so as to enable him to obtain written instruction and appraise this court as to whether the order of suspension issued to the petitioner was reviewed within the prescribed period of time or not.
My lord, can it be on 7/5, Lord?
7/5.
Okay.
7/5.
Yeah, my lordship. This is a promotion matter, my lord. The petitioner is deprived from the promotion to the rank of Subedar GT, my lord.
Petitioner is retired. Why don't you use the mic?
No, my lord. Deprived from the promotion to the rank of Subedar GT, my lord.
Hmm.
Due to lacking of the ACR, but that adverse entry has not been communicated to him, my lord. And as per the last order, my lord, the instruction was sought for whether the adverse entry is communicate or not.
Lordship, Paris comments have been received and we have prepared the affidavit and sent to the department for vetting. Now, this issue has been taken care of the affidavit, Lordship. In the Paris comments, what it has been stated, Lordship, in the year 2019 to 2020, his ACR confidential report, that number was of 5. That means, Lordship, average. It is not bad, it is average. And that is not an adverse matter.
So you are filing affidavit.
So Lordship, we are filing affidavit.
You are appearing for respondents.
All the
You are appearing for all the respondents.
all the responsibilities.
All right, and so we'll issue notice, then let him file affidavit.
My lord.
These matters can't be decided without affidavit. You take down. I heard Mr. V. Kumar, learned counsel, appearing for the writ petitioner. Also heard Mr. C.K.S. Borua, learned CGC, appearing for the respondents. The petitioner hearing, who is serving as Naib Subedar bracket GD in the Assam Rifles, is aggrieved due to non-consideration of his case for promotion to the rank of Subedar bracket GD on the basis of uncommunicated adverse entries in the ACR. First up, Mr. C.K.S. Borua, learned CGC, submits that 3 weeks' time is required to file affidavit denying the claim of the petitioner. In view of the above, issue notice returnable in 4 weeks. Since Mr. Borua has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisitive numbers be furnished to the learned CGC. Counter affidavit of the respondents be positively filed within 3 weeks from today by serving advance copy upon the petitioner's counsel. Let the matter be listed accordingly.
My lord. GP.
The petitioner is serving as a constable in the Central Reserve Police Force. He's agreed by a transfer. He has completed 21 years of service in the Reserve Force. My lordship will find it the transfer at page 21. Serial number 20 is the petitioner. This is dated by the 24th of January from the last person, my lord. He has been transferred from Silchar to 200 Battalion, which is at Delhi. It's a good posting, my lord. Otherwise, it's a good posting. Delhi is a good posting.
Silchar to?
Delhi.
Hmm.
Delhi, my lord.
Yes.
Now, my lord, all throughout my career, I have always served at hard postings, except when they have posted me to Assam and all. Now, I am due to put in my papers for superannuation and completion of 20 years in 2026. I was praying for a retention in this place. for a year, which their provisions might not allow, Lordship would find at page 34, which is called a terminal posting. Page 34. The last one, my lord, Roman 6, Lordship will find Roman 6, terminal posting. Officers, personnel who are due to retire within 2 years to be reckoned from cutoff date may be considered for a terminal posting of his place of preference or to nearby place or location covered by overnight journey by train, provided he was not posted in the previous tenure. Officers who have not availed home state choice posting in 20 years of service. I have completed 20 years. I have never availed the choice
No,
posting.
Mr. Majumdar, see, this clause may have some bearing if your retirement is within 2 years.
Yes, madam.
But you intend to file a voluntary.
My lord, that is the application that I had made to them, that I will retire in 2026 because of my medical problem. I am in shape 3. I cannot continue in the service even because of my medical problems, and now my mother is also facing problems. What I would pray today, my lord, is if Lordship directs them to reconsider my application on these 2 grounds, that I will be putting in my papers in 2020 for retirement in 2026. I will go home. I make a commitment to the court, and my lord, that I have never availed a choice posting. In any case, if they relieve me tomorrow, day after, whenever, I get around 15 days to go and join at Delhi. I get that break. So if they decide the matter within the next 2 weeks, whether I can be considered for a terminal posting on my assurance that I am retiring in 2026 and that I have never availed a choice posting, let them take a decision within 2 weeks. Let them release me. If they cannot maintain me, I'll go, my lord. There's no difficulty. But if a consideration can be given once it was rejected, I will be fair, my lord. It has been rejected once. CRP. It has been rejected, and therefore I'm before this honorable court. Lordship will find the rejection at page 29. One-liner rejection being devoid of merit.
So after it is rejected, then.
My lord, this is a one-liner rejection. We do not know whether they have considered it on that aspect or not. When I had put in the application, I had given it in writing that I would be putting in my papers in 2026. Lordship will find it page 19. That part is not reflected. Why I could not be given a terminal posting at this stage, and why my choice, since I have not
Where is the
availed
transfer
choice.
order? Where
My
is the
lord,
transfer order?
transfer order, Lordship will find it page 21. The last person is me, my lord.
This is the order of January 2025.
But Lordship will find that para to the transfer would be effective from 1st of April 2025. Now, once it is effected, they start releasing the persons one by one, and it is completed by 30th of June. That is also there in their standing out in their.
So go and join in Delhi, and after that.
My lord, what I was saying is, even if they release me tomorrow, I will still have 2 weeks joining time to go and join there. Let them take a decision before I am required to join there. That is what I was saying. Once I join there, leaving my mother here, who's also a patient, my lord, there is a certificate there on record. I leave her and go otherwise. But if they take a decision, it's an overnight journey. I can go and join after two weeks if they reject it. But during this time, if they take a decision to retain me here, then the entire journey would be.
Matter we taken on Wednesday and take instruction like Wednesday motion column.
So be all right. But Mr. R. Majumdar and counsel for the petitioner peruse the statements made in the writ petition in view of the limited nature of relief prayed for by the petitioner. That is, for issuance of a direction upon the authorities to consider his prayer for choice posting.
Retention, madam.
For retention in Silchar, in view of the fact that the petitioner has submitted an application. You already submitted.
Madam, I have said that I would be submitting.
Petitioner,
but I will submit.
to
It's a
submit an
commitment.
application for voluntary retirement with effect from.
Madam, in the year 2026.
No, in the year could January, could be December.
It will be sometime in May, madam. May 2026.
With effect from the month of May 2026. Miss A. Gayan, Lineage CGC, 6 posting of this matter again on Wednesday, date to deliver, so as to enable her to obtain preliminary instruction.
I'm obliged.
Prayer allowed, list accordingly.
Somebody give me. As you.
Next, please, your lordship. Lordship, the petitioner applied for the post of lordship constable in the CAPF, lordship. And pursuant to advertisement dated 24/11/2023, lordship. Then he was under OBC category, lordship. And he belongs to Newar community of lordship, Gorkha Newar community, which is recognized as the OBC in the state of Assam. And pursuant to his selection, lordship, offer of appointment was issued at page 25.
So this notice has to go.
Notice.
For Mr. A.R. Terwilder, learned counsel for the writ petitioner. The petitioner had participated in the recruitment process for filling up a number of posts of constable bracket GD in the CRPF. First of all. However, despite the respondents had cancelled the candidature of the petitioner on the ground that the subcaste within quotes never NEWAR unquote does not come within the OBC category of Nepali community as per the list issued by the central government. Hence this writ petition. First of Mr. S.S. Roy, Learned CGC appearing for the respond numbers
1, 2, 3, 4, and 5.
1 to 5 days for some time to seek instruction. Notice of motion, issue notice of motion returnable in 6 weeks. Since Mr. Roy, Learned CGC has appeared and accepted notice for respond numbers 1 to 5. Miss Toshi, so and so for respond number 6, and Mr. J.K. Goswami, Learned Additional Senior Government Advocate Assam for respond number 7. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers be furnished to the Learned Departmental Council so as to enable them to obtain instruction and file affidavit.
Obliged. Motion.
Item 58.
Very pleased.
Yes.
Before Lordship, he was a deputy registrar of Cooperative Society, Cooperative Department. And there was department proceeding was initiated against him, for raising 5 charges, and he got the pursued inquiry, and inquiry report was submitted, where out of 5 charges, 3 were found to be not proved. 2 were not found to be proved. So for aspect of 3, there was no definite finding. Now, on the basis of the report, I have submitted my representation, and now the inquiry of the departmental authority, disciplinary authority, decided directing me to further cross-examine the witnesses. But that is not permissible. That you will also be kindly come to page 108, man. That is the order which is not challenged.
Yes.
Dealership Secretary, Government of Assam Cooperative Department, discussed in detail in inquiry report of the proceeding against so, which was submitted by inquiry officer, which was received by the department on 29/6/25. Copy of inquiry report forwarded to DO for submitting representation. File letter so. DO has raised objection, he was never allowed to cross-examine. The matter by inquiry officer, file letter received so. Subsequent letter was issued by the inquiry to hold further inquiry to cure the defects in the inquiry report, if any. File letter dated so. Now, in response to notice issued by the DO, attended hearings, did not attend the hearing, while letter received so. It was decided the inquiry will continue and conclude the inquiry, submit inquiry report department, irrespective whether DO attends the hearing when called for by the inquiry, the same is communicated due. When the inquiry is already completed, my lord, inquiry report is submitted under Rule 9A. Either he has to agree with the findings or disagreement. He cannot direct for further cross-examine witnesses. That is not permissible.
My lord, I may not agree, my lord, with my learned senior friend.
See, before you argue,
Yes.
prima facie inquiry to hold further inquiry to cure the defects, which is obviously not permissible.
Yes.
2 options. We'll admit it, issue rule, stay the entire proceeding, 4-5 years will go. Or you can obtain instruction and withdraw this communication.
Yes, my lord.
Which of the 2 you want
My
to
lord,
choose?
the latter one I will, my lord,
accept, my lord, I will agree, my lord, to accept it. But before that, can I, my lord, make one submission, my lord? My lord, so far as the submission is concerned, that this is not permissible, my lord, I disagree with that. Because the language may be, my lord, here the language which appears in the communication, that may not be correct to cure the defect. My lord, what I'm on, my lord, this decision has been taken to ensure, my lord, fairness in the inquiry. Because, my lord, under the, my lord, the departmental manual rules, this is permissible. Because after the completion of the inquiry, my lord, the inquiry report was furnished to him. Now, amongst others, the delinquent had taken a ground that he was denied of cross-examination, my lord, in respect of 2 witnesses. So, therefore, that meant, my lord, that there was a denial of a fair trial. So, this particular aspect, my lord, was brought to the notice of the, or it had invited the attention of the disciplinary authority. Now, the disciplinary authority, my lord, to remove the irregularity and to cure the defect, my lord, thought it proper to allow him to further cross.
No, this you can't. Your inquiry report is gone.
No, my lord, inquiry report will go. I understand, my lord. Inquiry report will go. If your lordship sees, my lord, the departmental manual, paragraph 6.18. My lord, there are 2, my lord, provisions, my lord, which says, my lord, may I read it? Where the disciplinary authority, it is 6.18.1. Where the disciplinary authority on a contention raised by the person proceeded against or otherwise finds that any material irregularities have been committed and they have caused or they may have caused prejudice to the person charged, or such irregularities are likely to vitiate the proceedings, it will consider 2 aspects, my lord. Number 1, whether the whole inquiry should be set aside and a fresh inquiry started de novo. This is 1, my lord, option. The second one is whether the inquiry be set aside from the stage of occurrence of irregularity and it be ordered to be started afresh from that particular stage. Here, my lord, my respectful submission is inquiry report will go, but it will start from this stage.
Then you pass an order.
Yes,
You
yes,
pass
correct.
some other order.
Correct, brother. Correct.
Heard Mr. P. Kotovil and counsel appearing for the writ petitioner peruse the amendments made in the writ petition. The order dated 21/3/2025 issued by the Additional Chief Secretary to the Government of Assam Cooperation Department, inter alia, directing a further inquiry so as to cure the defects in the inquiry report has been assailed inter alia on the ground that such an order is violative of principles of natural justice and administrative fair play. Mr. S.K. Talukdar, learned standing counsel for the Cooperation Department, seeks posting of this matter again on 2/5/2025 so as to enable him to obtain instruction and address this court. Prayer allowed. This 2 extra copies of the writ petition be furnished to Mr. Talukdar. List this matter for admission for motion again on 2/5/2000.
Correct.
You pass that order, then
Yes,
you
yes,
set aside.
my lord, in fact, the writ petition, my lord, I don't know whether this order has been passed or not. There are certain, my lord, omissions, my lord. Even the petitioner does not say whether he had received the notice of the inquiry officer. So whether the order has been passed or not, I'll bring on record.
That is not material.
My lord, my lord.
Material
Correct.
is that once the inquiry
Yes,
report,
yes.
you have brought the process to an end.
Yes, yes.
Now you cannot do other activities and then tinker with the
inquiry
That's
report
not
cannot
permissible.
sustain. I agree to that. Deeply obliged.
This matter pertains to the promotion to the post of Anganwadi worker to Anganwadi helper lordship. Here the private respondent number 5, he belongs to a particular revenue village, as she has been promoted to the post of Anganwadi worker in another revenue village lordship. That's my case, which is violation of the prevailing guidelines.
Notice?
Yes.
Notice?
Lordship.
Heard Mr. A.Z. Ahmed, learned counsel for the writ petitioner, peruse the amendments made in the writ petition. The matter pertains to claim of the petitioner for promotion to the post of Anganwadi worker from the post of Anganwadi helper. Mr. Ms. A. Talukdar, learned government advocate for the
For 1 to 4, Lordship.
learned standing counsel for the social welfare. You are standing
Lordship,
counsel.
government advocate.
And
Lordship.
government advocate for the government advocate Assam. Appearing for respond numbers 1 to
4, Lordship.
4. Why not 3?
1, 2, 3, and 4, Lordship.
1 to 4. Has prayed for some time to obtain instruction in the matter. And 4 weeks since Ms. Talukdar has appeared and accepted notice for all the respondents. No formal notice is required to be sent in this case. Extra copy of the petition, requisite in numbers, be furnished to the learned G. Assam so as to enable her to obtain this.
Private respondent is there, Lordship.
Yes.
Private respondent.
Hi.
Yeah. Respond number 5, Lordship.
Okay. No formal notice to 1 to 4. So and so, so and so. Petitioner to take steps for service of notice upon respond number 5 by registered post with AD. Then make it 6 weeks. Yes.
Obliged, Lordship.
Admission, item 13.
That be the watch. Lordship may recollect, the last occasion when this was heard, it appeared that there is another matter which filed by the private respondent here, the deed and director, challenging his retirement because he has also been asked to go on retirement. There was an interim order of this court, and he claims that he is continuing. That matter was heard by different courtal bench. Therefore, Lordship was of the view that if that is over, then it would be an added ground to look into this aspect. And we all agreed. Accordingly, it was fixed. Unfortunately or fortunately, that matter has been released from being part. Now it is hanging. Therefore, that matter is no longer being kept as part heard, that has been released by the learned judge. Therefore, now I will pray that let that matter, what is the WPC?
3769.
3769 be listed along with this on some other day, so that Lordship can hear both the matters. It is already part heard, let the other one also come. If they have anything to submit, we can all participate there and we can trust. Another prayer, we have filed an miscellaneous application, IA, interlocutory application, because I have been served with a notice to vacate the quarter from that campus. So.
Okay, what is the number of the IA?
IA. Number is not yet numbered, Ballad. Filing is filing number, serial number 5086. This is the serial number. So can it come up day after tomorrow?
Okay, at the moment, we'll pass an order for listing of the IA.
Yes.
Rest we'll see. Yes, Mr. K.K. Mohantal and his senior counsel appearing for the writ petitioner herein submits that interlocutory application being IA filing number
5086.
Seeking urgent order from this court. IA number so and so arising out of WPC number 6016 seeking urgent order from this court has been sought. But the same has not been listed today. Expressing urgency in the matter, Mr. Mohanta has prayed for posting this writ petition along with the IA day after tomorrow. We'll have it on Thursday. Give Thursday's date as fixed item. Mr. K. Gogoi, learned CGC, appearing for respond numbers 1. Mr. A.K. Datta, learned
234.
CGC, appearing for respond numbers 2, 3, 4. And Ms. R. Das, R. Kakoti, learned counsel, appearing for the private respondent number 5, are present and do not have any objection to the said prayer. In view of the above, register to raise this writ petition along with the interlocutory application for orders again on
First of May.
On 5.
Apply.
Lordship, kindly the matter may be taken up after some time, Lordship. Mr. Z. Goswami is appearing in this matter, Lordship. He is on legs, Lordship.
What is the matter about?
Matter brief is not with me, Lordship. I'm not in the case, Lordship.
This has to be fixed for hearing. This is against the order of,
Tribunal, Lordship.
let him come, we'll fix it for hearing. These are not matters of admission.
Yes, Lordship.
We'll admit it and then hear it.
Lordship, after 5 minutes, Lordship.
Why don't you ask him and come back? Agree on a date, we'll admit and fix for hearing.
Yes, Lordship. After 5 minutes, Lordship, he is in. Okay. Obliged.
Lordship, I am appearing on behalf of Mrs. Gauura, my lord. Due to water logging, she could not come, my lord. So this matter may be taken after 2 weeks, my lord.
On the prayer of learned counsel made appearing for the writ petitioner made with the consent of the other side, admission hearing and stands adjourned for
My
2 weeks.
May it please the lordship. Similar matters were disposed of by this honorable court. May I just the issue, your lordship, in this case relates to the pay protection. And subsequently, a notification was issued saying that the DRDA employees will be absorbed in the PNRD department. Their pay protections will be taken care of by the government, that is the finance department. So that was the issue which was put to challenge. Now subsequently, they came up with a notification. Therefore, this honorable court was pleased to dispose of the matter in a similar line, your lordship. The lordship will kindly turn to page 31.
Page 31. Yes.
The learned counsels for the parties submit that both the petitions have become infructuous in view of the notification number dated such and such.
Page 31 of what? Writ petition?
No, your lordship, page 31 of the order copy I gave. I'm sorry, your lordship.
Yes.
The learned counsels for the parties submit that both the petitions have become infructuous in view of the notification number such and such issued by the Principal Secretary of the Government of Assam, PNRD, issued by the Under Secretary Finance. Then the notification is there. The next page, your lordship. The Governor of Assam is pleased to accord approval for protection of pay of 477 numbers of DRDA born employees as per NHRA absorbed in the Zilla Parishads, Anchalik Panchayat development blocks and Gaon Panchayat against the existing sanctioned vacant post of identical pay scale of the stage, which they have been drawing in their earlier post before absorption under such and such, subject to the condition that there is no gap period between the date of discontinuation, DRDA, and joining under ZPs, APs, development blocks, and GPs, etc. They are absorbed against the sanctioned vacant post of identical pay scale. This has been issued as per the Finance Department concurrence under such and such. So in view of this.
So your clients are also among the 477?
Yes, your lordship.
I am not aware about this one. Can it be after some time? I will go through the notice.
Examine if it is covered, then.
Yes, sir. Can be. 20, my lord, I am appearing on behalf of Mrs. Gauura, same prayer, my lord.
Paid for by petitioner's counsel, this matter stands adjourned for 2 weeks. Ms. A. Gayan, and CGC is present on behalf of the respondents.
In item number 25 is also, my lord, possible.
Wait.
My lord. Yeah, the affidavit is ready, my lord. I will be able to file it by Wednesday. Can it be, my lord, any day, my lord, after 1 or 2 weeks for admission hearing? Take a point, my lord, that is.
Mr. Arsenal and counsel is present for the writ petitioners. Writ petitioners in this batch of writ petitions. Mr. B. Gogoi, learned additional AG for the state of Assam, has appeared in submits that counter affidavit on behalf of the department is ready and shall be brought on record during the course of this week. As such, he has sought posting of these matters again after 2 weeks. Prayer is allowed, subject to filing of affidavits during the course of the week. These matters are directed to be listed again in the 3rd week of May 2025. Yes. What is this? Who is appearing for the petitioner? Yes. Mr. Talukdar, you are appearing.
May I please, Lordship, kindly pass off the matter for time being. My senior is in another court number 4.
What is this matter about?
My lord, is removal, my lord, of the secretary after inquiry, my lord.
So you have filed affidavit.
It's a old matter, my lord. In fact, I have been handed over the case by the earlier set of counsels. Perhaps, my lord, affidavit is not filed.
Acha, you do one thing, have a look at the record.
My lord,
We'll pass it over for some time.
my lord, my lord.
Who is your senior?
Mr. K.U. Ahmad, sir.
Let him come have.
Come,
a-
correct,
go through.
correct.
This matter may also come up after 2 weeks, my lord.
As paid for by petitioner's counsel, same order. Ms. A. Gayan for this.
Deeply endorsed.
No, so this matter is infructuous, Lordship, as the petitioner is died, Lordship.
You're Mr.
NH Lashkar.
Mr. N.H. Lashkar, learned counsel, appearing for the petitioner submits that the lead petitioner in this case has expired and there is no room for substitution. As such, the lead petition has become infructuous. Mr. I. Botaku, learned counsel, is present on behalf of the Forest Department, State of Assam. Taking note of the submission of Mr. Lashkar, this lead petition stands closed as infructuous.
I love this.
My lord, Mr. A. Bhuya is on leg in the other court. You may take up this matter after some time.
My lord,
Next week,
we have already filed affidavit, my lord. Maybe fees for hearing.
Affidavit you have filed.
Oh, we
When?
have filed, my lord.
When?
It was filed on 13/2/2023.
Actually, the affidavit is not on record. We'll ask the registry to take the affidavit.
Yes, sir.
Affidavit on behalf of?
On behalf of my lord, respondent number 3.
All right. Miss, your name, please?
S. Laskar.
S.
Laskar.
Lashkar, learned counsel is present for the petitioner. Mr. T.C. Chutia, learned additional senior government advocate Assam appearing for the state submits that affidavit on behalf of the respondent number 3 in this case was filed on 13/2/2025. However,
23.
Huh?
23.
13/3/2023. However, it appears that, oh yes, yes. The said affidavit is available on record. However, the petitioner has not filed any rejoinder. Be that as it may, on the request of learned counsel for both the sides. They filed affidavit. You want to file a rejoinder? No.
My lord,
Not filed.
I'll take up-to-date instruction. It's a pending.
How much time you want?
2 weeks, my lord.
Then next we'll I do on the request of Mr. A.R. Bhuya, learned counsel for the petitioner, then you write Mr. A.R. Bhuya. 2 weeks time is granted
My lord.
to him for obtaining instruction, updated instruction and filing rejoinder if so advised. Let the matter be listed accordingly.
Obliged.
Your Lordship, regarding non-payment of salary and written termination with preferred with petition, no affidavit has been filed as of now. Interim order is operating.
No affidavit has been filed.
Lordship, Mr. Esbora is on legs. He's praying for 3 weeks' time to file his affidavit.
Mr. Esbora is for respond numbers 2, 3 and 4.
PTC 1 to
Respond number 1.
WPT and DC department.
I'm appearing for respondent number 1, WPT and DC. Lordship, kindly directed to furnish the copy, Lordship, extra copies.
See, please use the microphone. The mic is somewhere you are talking, so yes.
I am appearing for respondent number 1, Lordship.
Hmm.
So kindly directed to furnish the extra copies, Lordship.
And Mr. Bora, you are for?
This for BTC.
BTC, my lord.
That is respond numbers?
224.
You want some more time?
Some more
file?
time to file the affidavit.
Sure. Then will interim order will continue.
There is interim.
Lordship may not be observed because already protected.
Ms. B. Buyal, and Senior Counsel is present on behalf of the petitioners. Miss, your name, please?
And on behalf of party.
And they, learned counsel for the respondent submits that she has not received a copy of the writ petition, as a result of which no affidavit could be filed on behalf of her client. Mr. S. Bora, learned counsel for the respondent, learned standing counsel, BTC, appearing for respond numbers 2 to 4, placed for further 4 weeks time to file affidavit. In view of the above, this matter stands adjourned for 4 weeks. Copy of the writ petition be furnished to the learned counsel for the respond number 1 within a week from today.
May it please your lordship, my lord. The matter pertains to compassionate appointment, my lord. The DLC, my lord, initially, my lord recommended my name for, my lord, any post, but my lord, SLC has rejected my, my lord, offer of the DLC, my lord, as I was not, my lord, competent, qualified for that post. Thereafter, I approached this honorable court, my lord. This honorable court by order dated, my lord, 17/11/2021, my lord, first order that I may be given the, my lord, post, my lord. And my lord, thereafter, my lord, DLC again, my lord, proposed.
Where is the order of the court?
Order, my lord, at page 58, my lord. And para 4 and 5, my lord, page 60.
Yes, then what happened?
Thereafter, at page, my lord, 70, my lord, the DLC has, my lord, again recommended my name, my lord, at page 70.
Yes, page 70.
Page 70, my lord, 701. Ratnadeep Roy, my lord. The applicant has submitted copy of the order dated 17/11/2021 passed by the Honorable Guwahati High Court in WPC number 6070/21 and request to consider his claim for appointment in grade 4 post on compassionate ground. In this context, it may be pointed out that the Honorable Court held that the claim of the petitioner was earlier recommended by the DLC for appointment in grade 3 post, and the SLC has rejected the application due to lack of additional qualification required for appointment to grade 3 post, and the Honorable Court has directed to consider the appointment to in grade 4 post. On call for the video not Coringus development block by letter dated 21/12/2021 has furnished the testimonies of the applicant, including the status of the vacancy in grade 4 post in his office, and it has been observed that there is no admissible vacancy in the aforesaid category of the post as per the quota of 5% in the said category of post. The DLC, in compliance to the direction of the Honorable Court, has decided to adopt the principle as provided as Gov. OM 5 dated 1/6/2015 at para 15, wherein it has directed that if sufficient vacancies are not available in any particular office to accommodate the person to waiting list for compassionate appointment, it is open to the administrative department office to take up the matter with other department office of the government to provide any earlier appointment on compassionate ground to those in the waiting list. In person of the aforesaid guideline of the Governor of the Administrative Department, video not Coringus has been requested to take up the matter with other department office, preferably under the PNRD department to other district of Assam where vacancy is admissible in grade 4 post as per the prescribed quota of 5% to provide an earlier appointment. My lord, thereafter, my lord, SLC has again rejected my prayer, my lord, at page 83, my lord. the committee did not recommend the following proposal for appointment of compassionate grant at grade 4 post as it did not fulfill the required criteria prescribed under when dated. If the age of the applicant was below 18 years at the time of.
So when was the application made?
Application was made, my lord, on 28/12/2015, my lord. And my lord, the father of the applicant was died on 13/5/2015. My lord, at first DLC meeting at page 37, your lordship peruse, my lord, at page 37.
So what was his age on 28/12/2015?
My lord, as age was, my lord, 17 years, 3 months, 29 days, my lord. But that was considered by the DLC at page 37, my lord.
No, but when he made his application, he was a minor.
My lord, therefore, my lord, my petition was, my lord, keep aside for the next DLC, my lord, at page 37, my lord. They have observed, my lord. Yes, page 41, it was, my lord, at para 12, my lord.
No, how can it be? We'll hear it in due course. This is the problem. It cannot be disposed of in admission. When the application was made, he was a minor.
Yes, my lord, but my lord, at page.
So there are a number of decisions which says the minor's application cannot be considered.
My lord, his age was 17 years, my lord. That is true, my lord. But in the DLC meeting, it was considered, my lord, and his age.
It could not have been considered.
It
was wrongly considered. And this fact was not dealt with by the learned single judge in the order.
Yes.
But
But because
now first question is whether his application was valid or not. Then if this is accepted, then anybody who is aged 5 years will file an application and wait for 13 years. And then say that, okay, now I'm major. Then what happens to all those cases which have been closed? All these will have to be reopened now.
if your lordship will come to my page 41. my lord.
Page 41.
41.
Yes.
In the last part, my lord, at 12. Block Development Officer, North Korimganj Block, has forwarded the claim of Sri Ratneswar Roy, my lord, and during examination of the claim, it has been found that the applicant would attain the minimum age of 18 years on 29/8.
So is this view binding on the court?
No, my lord.
Then
My lord,
this is not wrong. It could not have been done. What is your argument on that?
my lord, earlier, my lord, the SLC has.
They have done this. Don't repeat it again and again. What is the law? That's what I'm asking.
As per my lord, OM dated, my lord, his age should be minimum, my lord, 18 years, my lord.
Therefore, what is the legal argument? You make the legal argument. It is not possible to pass perfunctory orders. The question is, when he made the application, he was a minor. So that application was incompetent. How does the court act on an incompetent application?
In this regard, my lord, one judgment is of our High Court, my lord.
Show me.
In Hanif Ahmed Laskar case, my lord. In para 3, my lord. Being agreed, this writ petition is instituted. The law of compassionate appointment has its own procedure and principle to be followed, and the general principle applicable to a regular recruitment would not be applicable. It was always open for the respondent authority to have rejected the application of the petition on the ground that he has not attained the requisite age for a government employment, provided the said application was placed before the DLC concerned at the appropriate time. But having not done so, and allowing the applicant to remain pending for almost more than 30 years. Now the ground of the rejection that the petitioner was 15 years, 8 months, 28 days on the date of submission of the application would not be inapplicable. Is as well, it is applicable for compassionate appointment, not an application for regular appointment. For an application for regular recruitment, the principle of law. And in the next case, my lord, is my lord, in respect of review of the judgment of the earlier, my lord, this court has decided the matter. That para, my lord, 7, 8, and 9.
Yes.
A reading of the order of the secretary makes it discernible that the secretary answer into the aspect of the SLC had already rejected the application of the petition on the ground of delayed submission, and therefore the secretary took a view that it should not be placed before the SLC any matter. In other words, the view taken by the secretary appears to be a judgment of the secretary over the judgment of the court dated 2/4/2014 passed in WPC also. In fact, in the order of the secretary, the order of the court dated.
So you are reading Anupam Saikya?
Anupam Saikya.
Which para?
Para, my lord, 7, 8 and 9.
Yes, what is the stand in the affidavit?
My lord. At para 4, my lord, of the affidavit, it stated that the report stated in fact that the application of the petition was kept pending by the district level committee in its meeting held on 27/2016 till attaining the age of the entry of the government service, my lord.
Yes, so this affidavit is by respondent number?
Respondent number, my lord, 7, my lord. DLC, my lord.
Yes, who is appearing? You are appearing for
DLC and SLC lordship.
respondent numbers,
Lordship, respond number 5 and 7 lordship.
5 and
7.
and what about the others?
The PNID department lordship. The
So
lordship,
we'll allow the writ petition.
lordship, it is an admitted fact that lordship that when the application was made, the petitioner was minor lordship. He was
Correct, but you have not returned his application. You have kept it in abeyance.
lordship.
Otherwise, you would have submitted a fresh
The
application.
SLC has rejected lordship. On the rightly, he has rejected. That is rejected lordship. That the at the time of application, it was he was
Correct,
only
correct. So the DLC did not return his application. It was kept pending. Otherwise, he could have filed a fresh application after attaining majority.
But SLC has rejected lordship.
All
And
right,
lordship,
heard Mr. N. Sarkar, Learned Counsel
and
appearing. for
lordship,
the-
there is I would like to cite in the Supreme Court judgment lordship. 2007 SSC 192 Sanjay Singh versus State of Bihar lordship. where it says that parents to apply for a compensation appointment when the child was minor, lordship, and on attending the majority, it is not admitted, lordship. Compensation appointment claiming for mother's post after attending majority claim rejected as time barred, lordship.
So the petitioner would become 18 years on which date?
My lord, 2000, my lord, 16, my lord, 38, 2016, my lord.
And that it will be a time barred, lordship.
Right. You want to give that decision?
Lordship, the judgment, I have to. A copy. I'm
Can
just-
you cite it next time? Without citing the judgment, it's not possible. Right, now had Mr. N. Circle and counsel appearing for the writ petitioner, also had Ms. A. Talukdar, Learned G. Assam, who has appeared for respondent numbers 5 and 7. None has appeared for the remaining respondents, although the name of the learned departmental counsel have been duly reflected in the cause list. Full stop. This is the second round of litigation when the petitioner has been compelled to approach this court by filing the present writ petition, seeking a writ of mandamus, directing the respondents to consider directing the respondent number 5 to consider his case for appointment on compassionate ground in respect of a grade 4 post. Full stop. The facts and circumstances giving rise to the filing of the writ petition maybe are briefly narrated here and below. Full stop. That the deceased father of the writ petitioner, namely late Ratnatosh Roy, was serving against a grade 3 post of Gram Sevak. Full stop. Gram Sevak. Full stop. He died in harness on 13/5/2015, leaving behind his wife and the son, and the son, that is the writ petitioner. His wife, a son, that is the writ petitioner, and his daughter. Full stop. Having lost the sole breadwinner in the family, the petitioner had submitted an application on 28/12/2015 with a prayer for appointment on compassionate ground. Full stop. It is the admitted position of fact that on the date of submission of the application, the age of the petitioner was 17 years,
3 months, 29 days.
17 years, 3 months, 29 days. Full stop. Therefore, he was admittedly and evidently a minor on the date of submission of his application. Stop. Upon receipt of the application dated 28/12/2015, the DLC of District Karimganj had considered his application and thereafter had recommended the case of the petitioner for appointment against a grade 3 post. Full stop. However, the said recommendation of the DLC was rejected by the state level committee, SLC, on the ground that the writ petitioner did not have the qualification for being appointed in respect of a grade 3 post. Full stop. Aggrieved thereby, the petitioner had approached this court by filing WPC number
6072.
607/2021, inter alia contending that the application of the petitioner for appointment of on compassionate ground was in respect of any post and not a post in grade 3 category. Therefore, the ground for rejection of the application by the SLC was wholly untenable in the eyes of law. Full stop. After taking note of the grievance of the petitioners and as agreed to by the learned departmental council, WPC number 6072/2021 was disposed of by the learned single judge by order dated 17/11/2021 with a direction upon the respondents to consider the case of the petitioner for appointment on compassionate ground in respect of a grade 4 post. Full stop. Pursuant to the above direction, there was a fresh DLC.
Yes.
Where is the fresh DLC?
Page 70, my lord.
Page 70.
The DLC, my lord. Recommendation.
The DLC of Karimganj district wide resolution adopted in the meeting held on 18/01/2022 had made a fresh recommendation in favor of the petitioner for appointment against a grade 4 post by acting in terms of the OM dated 01/06/2000, para 15 of the OM dated 01/06/2015 issued by the government of Assam, whereby it was provided that if sufficient vacancies are not available in any particular office to accommodate the person in the wait list for compassionate appointment, it would be open for the administrative department office to take up the matter with other departments, public offices of the government to provide an early appointment on compassionate ground to those in the waiting list. Notwithstanding such a recommendation of the DLC, the SLC wide resolution adopted in its meeting held on
8/2022.
02/08/2022 had once again rejected the application of the writ petitioner, this time, on this occasion, merely on the ground that the writ petitioner was below 18 years on the date of submission of application. Full stop. Aggrieved thereby, the present writ petition has been filed. Full stop. By inviting the attention of this court to the original recommendation of the DLC adopted in its meeting held on, which is the original one?
At page 37.
Meeting held on
27/2016.
Hmm. 2007/2016, Mr. Sarkar, learned counsel for the petitioner, has argued that it is no doubt correct that on 28/12/2015, when the application for compassionate appointment was submitted by the petitioner, he was below 18 years of age. However, the said fact was duly taken note of the DLC, whereby a decision was taken to keep the application in abeyance till 29/8/2016, on which date the writ petitioner would attain the age of 18 years. Full stop. Accordingly, his application was kept pending to be taken up only after the writ petitioner had attained majority, that is the age of 18 years. Under such circumstances, and in view of the intervening developments, Mr. Sarkar submits that the claim of the petitioner could not have been rejected by the authorities by ignoring the mandate of the order dated 17/11/2021 passed by this court, merely on the ground that when the application was originally submitted, the petitioner was below the age of 18 years. In contending that this being a matter of compassionate appointment, Mr. Sarkar has placed reliance on two decisions of this court rendered in the case of Hanif Ahmed Lashkar versus State of Assam, represented by the Commissioner and Secretary to the Government of Assam and others, reported in 2022 SCC Online GAU 4, as well as in the case of Anupam Saikia versus State of Assam, represented by the Principal Secretary to the Government of Assam and others, reported in 2022 SCC Online GAU 737. He is relied upon. Responding to the above arguments, Ms. A. Talukdar, Leonard G. Assam has submitted that since the application in this case was submitted by a minor, the same would not have been acted upon by the DLC or the SLC. Therefore, the SLC has rightly rejected his application since the same was not valid on the date on which the same was submitted. Full stop. Urging that law is well settled that an application of the minor cannot be entertained for appointment on compassionate ground. Ms. Talukdar submits that since the SLC has rejected the application of the petitioner on legally justifiable grounds, there is no scope for this to interfere with the impugned resolution of the SLC. I have considered the arguments made at the bar and have also gone through the materials available on record. The basic facts are not in dispute. It is not in dispute that on 28/12/2015, it is also not in dispute that on 28/12/2015, when the writ petitioner had submitted the application seeking appointment on compassionate ground, he was aged below 18 years. As such, there can be no doubt about the fact that the application of the petitioner was not competent, and there can be no doubt about the fact that the writ petitioner was not competent as on 28/12/2015 to seek appointment on compassionate ground. Be that as it may, a perusal of the resolution dated 27/2016 of the DLC Karimaj unequivocally goes to show that the DLC was aware of the said fact and accordingly had kept the claim of the petitioner pending till the time he attains the prescribed age of entry in government service. There is no dispute about the fact that the application of the petitioner was not returned on the ground that he was a minor on the date of filing the same. Not only so, the SLC also did not reject his application in the first round by resolution dated what was the first resolution, first round?
Well, at page 14 and dated 15/2/2019.
Dated 15/2/2019 on the ground that the petitioner was underaged, but his prayer was turned down on the ground that he was not qualified for being appointed against a grade 3 post. Full stop. In the case of Hanif Ahmed Lashkar Supra, this court, while taking note of similar situation and while dealing with a question of similar nature, has made the following observations in paragraph 3, which are reproduced herein below for ready reference. First up, the said view has further been reiterated and reaffirmed in the decision of Anupam Saikya Supra. First up, what would be significant to note here in that the DLC, as noted above, the DLC did not return the application of the writ petitioner, but had kept it pending. Full stop. Had the application been returned on the ground that he was a minor, the petitioner would have had an opportunity to submit a fresh representation immediately on attaining majority, which opportunity was not available to him since the application of the petitioner was kept and his claim for appointment on compassionate ground was kept pending. Full stop. Even the SLC did not decline the request of the petitioner in its resolution dated 15/2/2019 on the ground of the petitioner being underaged. In view of the above and considering the law laid down by this court in the case of Hanif Ahmed Lashkar Supra, this court is of the opinion that the SLC was not correct in law in declining the prayer of the petitioner merely on the ground that he was aged below 18 years on the date of submission of the application. This court is of the view that having regard to the facts and circumstances of the case, the ground taken by the SLC was not valid for rejecting the prayer of the petitioner. On the contrary, in view of the specific directions issued by this court by order dated 17/11/2021, the SLC was duty bound to consider and process the application of the petitioner for appointment against a grade 4 post in accordance with law, which it had failed to do in the present case. Therefore, this court is of the opinion that this writ petition must succeed and the same is hereby allowed. The SLC is directed to consider the case of the petitioner for appointment on compassionate ground against any grade 4 post in the district of Karimganj and issue appointment orders accordingly. The consideration will be made in the next meeting of the SLC. A copy of this order be furnished to Ms. Talukdar, Learned GS for doing the needful. Each petition stands disposed of accordingly.
Sorry, I was not in the court. My name may be recorded in the Panchayat.
You are appearing for?
Panchayat department. Yes, sir.
No, can you give the respondent's name? Which respondents you are?
Yes, sir.
Standing Council Panchayat Department. Has appeared.
Much obliged.
Mr. Datta, you give the name of the respondents. Whom you are-
Your Honor, as per the last order, Lordship, my learned friend has to submit the instructions regarding the form number 20A has been submitted or not.
This is over, but another decision is checking clarification from pension and public and pension given department, whether she will be, the lordship may be, because lordship may be. The question of CFP is also there. That's it. One query was made on 27 March. As soon as we get.
Just 1 minute.
My lord, my lord.
So the petitioner's grievance, first the amount is not correct and the pension, family pension has not been disbursed.
Yeah, there is one. Everything will be settled, my lord. We will settle everything. Only this clarification is required from the concerned department. We have written later. As soon as we get it, we will clarify. Whether manner it is used, what manner it has been clarified is up to them.
So you have received something?
Yes, Lordship.
What have you received?
Lordship, my submission is that, Lordship, as per this, as per the scheme 2017, the petitioner is entitled compensatory family pension initially till the date of superannuation, deemed superannuation. So thereafter, it is converted to normal family pensions. But here, the family pension has been granted on 3/4/2024. Actually, the family pension has to be started from 1/1/2022. And compensatory family pensions is started from 3rd of November 2019 to deem date of superannuation, that is 31st/12/2021.
Department, PPG. PPG instruction lagi. Kita clarification lagi PPG department.
So they want some clarification.
Yes, my lord.
From the
Lordship, in this regard, Lordship, my submission is that, Lordship, law, what is the notification?
What do you want, the final judgment today?
Lordship,
Argue.
Lordship, my submission is that, Lordship, whatever their required clarification, everything is settled, Lordship.
Then argue on merit, either we'll accept it or reject it. They are seeking some clarification from the government. If you seeing that clarification is not maintainable, then you argue. But you will either succeed or fail. And then there will be no reopening of this issue. Or you can wait till the clarification is given.
Lordship, just I point out this thing, Lordship.
No, don't just point out. We are not sitting here just to listen to anything. You want a decision of this case, then argue. Today you want a decision.
Lordship, they are seeking clarification, Lordship.
PPG department, sir.
Heard Mr.
PPG.
I Hawk Learned Counsel for the petitioner. Also heard Mr. T.C. Chutia Learned Additional Senior Government Advocate Assam. Mr. N. Upadhyay, Learned Standing Counsel for Irrigation Department, and Mr. Dupamanu, Learned Standing Counsel, Finance Department. Mr. C. Borwa, Learned Standing Counsel for the Office of AG Assam, has appeared and submits that the claim of the petitioner has been substantially redressed and the amount has already been released. However, there is a small clarification required in this case as regard the entitlement of unmarried dependent daughters pertaining to CFP. What is CFP?
Compassionate Family Pension.
Compassionate Family Pension Scheme. And as soon as such clarification as called for from the department is received, the matter will be
We'll
deal with it conclusively.
Right.
First up, the Learned Counsel for the petitioner has also agreed that the clarification as called for by the Office of AG Assam is required to be punished by the department. Which department will do that? Mr. Tusi Chutia, learned.
My lord, I have received a letter to the Director of Pension, my lord. Director of Pension says this case is not related to this department. They are not dealing with this matter.
Then who is to deal with this?
Director of Pension says, my lord.
It is
This is my letter.
23 to 2023 letter. Because whenever ambiguity is there, my lord, regarding allotment or settlement, we have to go to the public department.
Correct. So which is the department here?
Here we are seeking from pension and public grievance department whenever queries are required for clearing some item. But regarding pension department is this one. Here department is not questioned. When in such type of ambiguity or whatever we are to take decision, we go for public and public grievance. That is our clarification. We have to go to them only.
That is right, but there is another dispute here. Who is the department?
Yes, madam. They are saying they are not dealing with this matter. They are dealing with only teaching and non-teaching staff of provincial school, DRDA department and junior government.
But here the question of policy, my lord, policy decision.
Irrigation is department, my lord. So
The concerned department to furnish its reply in response to the communication dated 26/3/2025 issued by the Senior Accounts Officer, Office of Principal Accountant General (ANE) Assam, within 3 weeks from today. A copy of this order be furnished to Mr. Isi Chutia, learned Additional Senior Government Advocate Assam, for doing the needful.
Hello. Problem.
May I please, your lordship?
Yes.
Lordship, petitioner is a contractual employee, your lordship. His contractual agreement has been terminated on the ground of misconduct and misappropriation, your lordship. Petitioner was issued Procos notice, your lordship, to which he has replied, but finding that his reply is not satisfactory, your lordship, his contractual agreement has been terminated. My case is covered under the by the judgment of this honorable court and also passed by the honorable Supreme Court, your lordship. Lordship, kindly peruse the termination order, your lordship.
My lord, those cases where situations are different, my lord, because so-cause notice was not served in that cases. In this case, page number 45, lordship may kindly see, so-cause was served on him with the report of the inquiry was unclosed with the letter, my lord.
But your lordship, regarding that submission, your lordship, my reply.
Just a minute, just a minute. Those cases, it was stigmatic and was done
so-cause
without.
notice natural justice, violation of natural justice.
But in this case,
So-cause was, my lord, served, my lord, page 45, along with the inquiry report. Therefore, I'm praying for some further time to file affidavit, my lord. This case is different, my lord.
But
where is the impugned order?
Impugned order, your lordship, will find page 47, your lordship.
So now,
your lordship, on the basis of the same inquiry report, your lordship, another contractual employee of the same JP, your lordship, he was also terminated and he approached this honorable court, your lordship, by filing writ petition, which I have annexed in page 48 onwards, your lordship. And this honorable court held that, your lordship, as when the punishment is by way of termination is is by way of punishment, your lordship, then principle of natural justice as well as
That's
reasonable
what he's
opportunity,
saying. You have been.
reasonable opportunity has to be given, your lordship. I have,
That's been given. You filed your show cause.
but merely on the basis, submission of inquiry report is not sufficient, your lordship. This
Show me
honorable,
the law. Show me the law.
your lordship kindly peruse the page 52 of that judgment, which I annex, your lordship.
52 is all submission. Where is the finding? Mr. Mira, you will not be able to prepare and argue a case.
Page
on your
44,
legs.
44 is the observation of this honorable court. Page 54, your lordship.
Page
54, your lordship. Paragraph 15, may I read, your lordship? May I read, your lordship? It is too well settled that even in case of temporary employment, the principles of natural justice cannot be altogether abandoned. In the present case in hand, the nature of accusation against the petitioner is stigmatic, as there is a specific allegation against the petitioner of gross negligence of duty and misappropriation of government money with malafide intention, which appears from the show cause notice to the petitioner dated
How much time you want to file affidavit?
My lord, 3 weeks time may be granted.
Let him file his affidavit. You have to wait. But Mr. K. Mira, we'll give you 2 weeks.
My lord.
Mira Learned Counsel for the Writ Petitioner also had Mr. S. Datta, Learned Standing Counsel, PNRD Department, Assam, who prays for and is granted 2 weeks further time as last opportunity for filing affidavit in response to the allegations made in the writ petition. Let this matter be listed again in the 3rd week of May 2025 as a fixed item for
Well.
admission hearing.
Hello, please.
Yes.
Here, your lordship, petitioner has been transferred, your lordship, in violation of the notification issued by the PNRD Department, your lordship. Your lordship, kindly peruse page. Page 66 is the impugned order, your lordship.
Page
66, your lordship. This impugned order has been issued by the Chief Executive Officer, your lordship. And
So you have filed your affidavit
Yes, my, I'll file my.
and any rejoinder is required?
respondent number, private respondent have filed affidavit, which I have filed reply also, your lordship. They are private respondent. your lordship.
No, who has filed affidavit?
I filed.
Acha, and department?
Department not filed yet. I am going to file in my.
You want to file?
My lord.
So there is an interim order.
Yes, your lordship.
So how much time you need?
Well, 3 weeks in this matter. my lord.
All right. Mr. K. Mira, Learned Counsel is present on behalf of the writ petitioner. Mr. S. Datta, Learned Standing Counsel, PNRD Assam, appearing for the official respondents, prays for 3 weeks further time to file affidavit. Mr. J. Laskar, Learned Counsel is present for the private respondent number 6 and submits that counter affidavit 5. But you have written 6.
6, your lordship.
6, 5, I am appearing one. It's 6.
Submit that counter affidavit on behalf of this client has already been brought on record. Be that as it may, in view of the prayer made by the Learned Departmental Counsel, this matter stands adjourned for 3 weeks so as to enable him to file counter affidavit. Interim order passed earlier to continue.
Obliged.
Hello.
May it please your lordship. Lordship, though in this matter we have filed our affidavit on behalf of the directorate, lordship, I have received instruction on behalf of the government, lordship. I need 1 week's time to file my affidavit on behalf of the government, lordship.
But may I submit one thing, my lord? Yes, taken a stand from the very beginning. The case is fixed. Everything was complete. Readings was complete. Now this issue and one more thing, development is going on, my lord. That government has initiated the process of DPC for readers, where private respondent is also there for promotion to the post of professor. And if that be so, my lord, matter become infructuous, he will be eligible for that, because earlier for vice principal he was not eligible.
All right, we'll have it on 7th of May as a fixed item in the top of the list.
Yes.
Mr. K. M. Haloi, learned counsel is present on with the petitioner. Mr. D. Upamanu, learned standing counsel for the Health Department, Assam, submits that he has received some updated instruction and therefore this writ petition be adjourned for a week so as to enable him to process the same. Ms. R. Kakati, learned counsel, is present for the private respondent. Taking note of the submission made by Mr. Upamanu and in view of the urgency expressed in the matter by Mr. Haloi, this writ petition is directed to be listed again on 8/5/2025 as first item of admission hearing with the clear understanding that no further prayer for adjournment will be entertained from either side on the next date fixed.
This matter may be disposed of, Lordship. That matter has become infectious, my lord.
Mr. J. Laskar, why it has become infectious?
My lord, regarding upper age, relaxation of upper age limit, I was allowed, by interim order, and I participate in the selection process. Lordship, similar order.
Mr. J. Laskar, learned counsel for the writ petitioner, submits that pursuant to the upper age relaxation granted to his client, he had appeared in the selection process but could not succeed. As such, the writ petition has become infectious. Mr. D. Upamanu, learned standing counsel, Health Department, Assam, is present and supports the said prayer. In view of the above, this writ petition stands disposed of as infectious.
Highly obliged.
Is there any interim order?
No, Lordship, no. Lordship, similar order, Lordship. Only in this case, my lord, I was not allowed to participate in the selection. Because, Lordship, they have appeared before, they have come to the court one day after the last day of the.
Mr. J. Laskar, learned counsel for the petitioner, submits that the selection process in question has already been completed. But the writ petitioner was not allowed to participate in the same. Therefore, at this point of time, no live issue survives in this writ petition. Mr. D. Upamanu, learned standing counsel for Health Department, is present and supports the said contention. In view of the above, writ petition stands closed as infectious.
Highlight. But here the petitioner was recommended by DLC, thereafter by SLC, but he has not been appointed, my lord, due to an office memorandum, my lord, wherein it was decided the people who have died prior to 31/3/2017 will not be considered. But this office memorandum, my lord, was issued on, came into force on 18 September 2024, whereas he was recommended by the SLC by his meeting held on 02/03/2023. And in a order of this court, my lord, if my lord comes to page 37.
Page 37.
Page 37, that is the order of this court, my lord. It is to be noted, second paragraph, it is to be noted. It is to be noted that the said office memorandum dated 18/9, the one I am showing now, is with the prospective effect and the case of the petitioner having already been recommended by SLC in his meeting 1/3/2024, the said office memorandum is considered, in considered view of this court, would have no application of the to the case of the petitioner. The same is in this case also, my lord. Here the SLC recommended on 2/3/2023 and that is prior to the comments effective of the office memorandum dated 18/9.
So in this writ petition, you are aggrieved by what?
Well, not being appointed, even being recommended by SLC.
Where is the recommendation of the SLC?
Yes, madam. Page 25, madam. No, not 20, 30. 30, madam.
Where is the relevant part?
My last paragraph, Sri Montu Bayan. Paragraph, last paragraph. After deliberation, the committee found Sri Montu Bayan, son of so-and-so, to be eligible and recommended his appointment to the grade 4 post on compassionate ground in terms of clause 15 of the memorandum of 2015. with concurrence of the finance department, subject to availability suitable vacancy at a later date.
Yes, who is appearing?
Lordship, I am for an respondent, Lordship, appearing for one and two, Lordship. Lordship, instruction receive, instruction received, Lordship, file the affidavit, Lordship. Bring it on a record, Lordship.
This is
Right,
your
heard
point
Mr.
of
Munir
law,
Rani
man.
Correct. Munir Rani Council appearing for the writ petition. I also heard Mr. H. Chakraborty, learned G. Assam appearing for the response numbers 1 and 2.
1, 2, 4, 5, 6, and 7, Lordship.
1, 4, 5, 6, and 7 who
Lordship.
submits that he has received
No, no,
instructions and therefore be granted 2 weeks time to file affidavit.
Six is finance department.
No, Lordship. Sorry.
He is taking away your client. Snatching your client. You are not doing anything. Huh? Mr. Chakraborty, you are for 1.
Lordship. 1, 2.
Don't take away Mr.
1,
Borpojini's client.
4.
My repetition is 352. 352. So item number 40.
Lordship.
Yes, in item number
39.
39, you are for?
2, 1, Lordship.
1, 2, 3, 4.
Lordship, 2, 3, and 6. 2, 3, and 5. 4.
Item 39, Mr. S. Datta, Standing Counsel, Revenue Department. Mr. H. Chakraborty, learned G. Assam for respond numbers 2, 3, 4.
2, 3, and 4, Lordship.
Acha, Mr. S. Datta, 1 and 5 kar dibo, huh? And Mr. R. Borpujari, learned SC Finance for respond number 6. And in item 40, so let me see the record. You all are unable to even say
Lordship,
who you were representing.
Lordship, wrong file is coming, Lordship. Instruction is awaited, Lordship. Lordship.
My lord, item 40, instruction awaited from finance department. Already recommended by DLC, SLC.
Yes. You have the instruction, Mr. You are Mr. M. Datta.
Yes.
On the last occasion, my lord, we had placed the instruction before this honorable court. Proposal was sent to the finance department. We had put some queries and my lord returned it, my lord, to the parent department, my lord, that is the Food and Civil Supply Department, Consumer Affairs. That proposal has not been returned. It is still at that stage. I have just taken the, my lord,
Mr. M.
specific
Datta, learned
instructions
counsel
today.
for the writ petitioner, also heard Mr. R. Borpujari, learned SC Finance Department, Assam, who submits that the query raised by the department with the parent department, that is the Department of Food and Civil Supplies.
Yes, my lord, that date is, my lord, 27/11/2024.
On 27/11/2024 has not yet been responded to. Hence the delay. First up, Mr. H. Chakraborty, learned G. Assam, appearing for the Department of Food and Civil Supplies, Government of Assam, raised for 2 weeks time to resolve the matter. In view of the above, let this requisition be listed after 3 weeks along with item 39.
Yes. I'm sorry.
Finding administrators, I can.
I'm sorry, my lord.
That's all right. Yes. What are you challenging here?
Well, the order of the Central Government Industrial Tribunal, some labor code, in reference case number 12 of 2008, my lord, the order is, my lord, at page 11, my lord. Starting for page 11, my lord.
Page
11, my lord.
So it is an award under
Yes,
challenge. Then is there any interim order here?
No, my lord.
Then what is the award about?
My lord, regarding his, my lord, promotion, my lord. He was
Promotion?
directed, yes, my lord. My lord, the fact of the matter is, my lord, the petitioner was, my lord, working in the wagon repairing department, my lord, which was, my lord, closed down, my lord.
All right. So this matter has to be heard finally. We'll admit it.
Well, in fact,
January 2021, rule was issued, my lord. And it was
Subsequently, my lord,
Mane-
LCR
it
was
was-
called for on the last
last
occasion. That is why it
matter
has
was
again come for
already-
admission on again, my lord.
matter was already fixed hearing by order 30 July 2024. And last occasion, since the LCR not received, my lord, earlier occasion, my lord,
LCR has been received now.
received, my lord.
Heard Mr. G. Goswami, learned counsel appearing for the writ petitioner. Also heard Mr. A.K. Hussain, learned counsel appearing on behalf of respondent number 1(1) and 1(2). It is submitted at the bar that the writ petition has already been admitted and the records and the records as called for by the court have also been received. In view of the above and on the request of learned counsel for both the sides, let this matter be listed again in the month of June 2025 for hearing on a non-miscellaneous day.
Quickly, please.
Like, can I pray date, my lord, in the month of June?
Yes,
Any date,
July
my lord,
is-
since 2015 matter, my lord.
All right. 15th of July,
My lord,
not June, 15th of July.
15 of
15th of July.
July, my lord. Hello.
Already, my lord, they have been given the relief by the government itself. Their protection has been given.
Right. Take down. Heard Mr. R. Sinha, learned counsel appearing for the writ petitioners in this batch of writ petitions. Also heard Mr. B. Gogoi, learned additional AG, State of Assam, appearing for the respondents. Full stop. The petitioners hearing, petitioners in this batch of writ petitions were the employees of DRDA.
Yes. Their pay has now been protected, man. That is the relief they have been seeking in the petition.
After the DRDA had become defunct, the petitioners were all absorbed under the PNRD department. Full stop. The grievance of the petitioner is based on an apprehension regarding their pay protection. Full stop. Mr. Sinha submits that during the pendency of this writ petition, the government of Assam had issued notification dated 29/2018 protecting the pay of all the 477 numbers of DRDA employees, including the writ petitioners, and taking note of the notification dated 29/2018, several writ petitions have already been disposed of by this court. Several similar writ petitions have already been disposed of by this court. First up, in support of his above submission, Mr. Sinha has produced a copy of the order dated 29/2022, passed by the learned single judge in WPC number 2661/2018. First up, I have perused the same. Mr. B. Gogoi, learned additional AG Assam, on examining of the documents on record, has fairly submitted that the petitioner's case is covered under the notification dated 29/2018 inasmuch as pay protection has already been granted to the petitioners. If that be so, nothing further survives for adjudication in these writ petitions. Taking note of the submission made at the bar, these writ petitions stand disposed of by providing that the interest of the petitioners in this batch of writ petitions, insofar as their prayer for pay protection is concerned, shall stand covered by the notification dated 29/2018. First step, writ petitions stand closed.
May I please?
Yes.
My lord,
Today I am not fully cleared the matter, my lord. So a date may be, my lord. And two documents are required to file, my lord.
My lord,
You also have the file just recently.
my lord, yes, my lord, in fact, what has happened, if I do not disclose it, my lord, it will be not fair on my part. Certain development, my lord, have taken place in respect of this present issue, my lord. Now, my lord, coordinate bench of the learned single judge was, my lord, pleased to pass an order on 13/3/25 saying that, my lord, the registrar of the cooperative societies, my lord, has no jurisdiction and power at all to intervene in respect of the appointment and removal of the secretary taken in respect of any resolution taken by the board. Now, my lords, there is an appeal, my lord. In fact, being aggrieved by that order, an appeal is pending before the division bench, and it is most likely to come next week. I don't know, my lord. It will come
All right,
shortly.
please adjourn it.
Yes,
On
my
the
lord.
prayer of Mr. K.U. Amel, learned counsel for the petitioner made with the consent of the other side. Admission hearing of this matter stands adjourned for 3 weeks. Mr. S.K. Talukdar, learned standing counsel, Cooperation Department, Assam, is present for the official respondent, whereas Mr. Sigdar, learned counsel, has appeared on behalf of the private respondent. This is the matter accordingly. Yes.
Yeah, please.
My lord, one judgment has already been passed. That case will cover this case also, my lord. For non-receiving of remuneration of concerned employees, my lord, elected employees.
Representative.
Yes. Perhaps they have already getting, my lord. I have to take instruction whether these petitioners are there or not. I'll place that judgment, my lord, on the next day, my lord.
Heard Mr. M. Khan, learned counsel for the petitioner, also heard Mr. S. Datta, who is standing counsel, PNRD Assam, who submits that a recent judgment has been passed.
On the last year itself.
Submits that there is already a decision of this court covering the grievance of the petitioners raised in this writ petition, and therefore he be granted 3 weeks time to examine the matter and make submissions facilitating disposal of the writ petition. A prayer allowed, list this case again after 3 weeks.
My lord, I'll
Yes, for the petitioner on call, Mr. D. Bhattacharjee, learned counsel, is present on behalf of
5.
respondent number 5. Since the petitioner is absent today, this matter stands adjourned for 3 weeks. List accordingly.
Lordship, petitioner has already got job, my lord, in another department. So, my lord, it may be allowed, he may be allowed.
Mr. Your name, please?
M. Ali.
Mr. M. Ali, learned counsel for the writ petitioner, submits that his client has got employment in another department, and therefore he has instructions not to pursue the matter any further. Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing for the state, is present. Taking note of the submission of Mr. M. Ali, learned counsel for the writ petitioner, this matter stands closed as not pressed. Yes. Yes.
Lordship, affidavit ready, Lordship. I have to file, Lordship.
Affidavit on whose behalf?
Lordship, respondent 1, 2, 3, and 4, Lordship.
1, 2,
3, and 4, Lordship.
How much time you want?
Lordship, 2 weeks, Lordship.
Okay, Mr. So-and-so, learned counsel for the writ petitioner, is present. On the request of Mr. J.K. Goswami, learned an additional government advocate Assam, appearing for the respondent numbers 1 to 4. 2 weeks further time is granted for filing affidavit, which is stated to be ready. Full stop. Let this matter be listed again after 3 weeks.
May I please, your Lordship?
As per Lodging Court order dated 29/11/24, service in respect of the respondent number 4 has been completed, Lordship.
So let it be listed for admission then.
Appeal is pending. Appeal, what is appeal?
Heard, Mr. Your name, please?
Appeal is pending.
Yes, your name,
PLR.
please. You're Mr.
GC Bora.
Heard Mr. G.C. Bora, learned counsel for the petitioner. Also heard Mr. J. Handing, learned standing counsel for Revenue and Disaster Management Department, appearing for respondent number 1, and Mr. J.K. Goswami, learned additional senior government advocate Assam,
2 and
appearing
3.
for respondent numbers 2 and 3. Lojima Court order dated 29/11/2024 goes to show that service of notice upon respondent number 4 is complete. Registry to therefore verify as to whether any counsel has entered appearance on behalf of the respondent number 4 and list the matter thereafter for admission hearing with appropriate office number.
Good.
Okay.
May I please advise? As per Lodging order that 6/12/24 losses, service upon respondent number 1 and 2 have been completed loss.
My lord, I am appearing for the respondent number 1 and 2, my lord. I need to take instruction, my lord, 2 weeks, I may be allowed.
What about 3 and 4? For 3 and 4 and 5?
Info 5.
All right, Mr. K.D. Sharma, learned counsel is present for the writ petitioner. Mr. B.K. Sen, learned counsel has entered appearance on behalf of respondent numbers 1 and 2 and 6, 2 weeks time to obtain instruction. Mr. D. Das, appearing on behalf of Mr. B. Sharma. Who is for 3?
Three is Treasury Officer Deepu loss.
Is present on behalf of the respondent number 4, whereas Ms. N. Day, learned counsel has appeared for respondent number 5. Register to verify as to whether service of notice is complete. The Treasury Officer, this is standing counsel final.
Yes, ma'am.
Registry to list this matter again by reflecting the name of learned standing counsel, Finance Department for the Government of Assam, on behalf of the respondent number 3. Achha. Then you write Mr. B. Gogoi, learned additional AG, has appeared for respondent number 3. As such, additional AG Finance Department has appeared for the respondent number 3. As such, service of notice is deemed to be complete in this case. Let the matter be listed for admission hearing after when?
22nd
After 2
of
weeks. After 2 weeks.
Deeply obliged.
Lordship, instruction received, Lordship.
Termination from service, my lord. He was serving as Deputy Superintendent of Police, Darang District.
Instruction received, Lordship. I will file an affidavit.
Mr. M.K. Das, learned counsel is present for the petitioner. Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the respondent numbers 1, 2, 4, 5, and 6. Praise for 3 weeks time to file affidavit by urging that he has already received instruction. Mr. C. Borua, learned standing counsel for AG Assam, is present for the respondent number 8. However, none has appeared for the respondent number 3. Be that as it may, on the request of Mr. Goswami, 3 weeks further time is granted as last chance for filing affidavit. Register to list this case again on 15th of May. 15th of May will be no less than 3 weeks. 22nd of May, 2025 as a fixed item. Counter affidavit on behalf of the department be positively filed on or before the next date by serving advance copy upon the petitioner's counsel. 50, 51, 52, 53. Disposed of in similar line. You give the order.
I have already given to the
I do अपनी sign अब खाली case number to बोल दूँगा. Disposed of.
50, 51, 52, 53 similar.
And Miss RM Dekar नाम को दिवो. Petition. Same order. হেৰিৰ নামটো বদলিব খালি কেছ নাম্বাৰটো মই বদলিব আৰু give her name on this RM deck.
Wait, please, madam. This is an increment application. We have filed, madam. Original petitioner, she has expired during the pendency of the review application.
Okay, heard Mr. Iqbal, Iqbal, learned counsel appearing for the applicant, also heard Mr. B. Chakraborty, learned counsel representing the respondent. This IA has been filed with a prayer to impede the legal heirs of deceased opposite party stroke review petitioner.
No, we are the review petitioner.
Achha, this IA is filed for whom? For
the
implement,
opposite party.
implement of the opposite party in the review petition. Mr. Iqbal submits that the opposite party, namely
Srimati Kamala Fukan.
Srimati Kamala
Fukan.
Kamala Fukan, has expired on
18/11/2024.
18/11/2024 during the pendency of the connected review petition by leaving behind the legal heirs as named in para 4
Case 6
of the application. Since the cause of action still survives, hence the opposite party is required to be impeded by bringing her legal heirs on record. First of Mr. B. Chakraborty, learned counsel for the review petitioner, submits that he would have no objection if the prayer is allowed. In view of the above, and having regard to the submissions made at the bar, Sri Dijen Fukan, D-J-E-N, Dijen Fukan, and Srimati Smita Borwa, that is the husband and daughter of the opposite party in the review petition, respectively, are hereby impeded as opposite party numbers 1(1) and 1(2) in the connected review petition. Amended cause title in the review petition be filed within 2 weeks from today. IA stands disposed of.
My lord, may I kindly fix a date for my lord?
No, you file the amended cause title. then
My name may be shown, my lord. It has not been shown today also.
Let the matter be listed again by showing the name of Mr. A. Iqbal and counsel for the applicant stroke opposite party number
1A,
1 and 1. 1A and
1B.
B. So 1A and 1B karo. 1A, 1 and 1, 2 na lage.
Obliged.
Yes. Yes, what is this item? What is the matter?
Lordship, it is even IA lordship.
None appears for the applicant on call. The applicant's counsel was absent even on the previous occasion. Ms. A. Talukdar, learned G. Assam is present on behalf of the state. Since the applicant's counsel is absent today, in order to give him one more chance to press this IA, let this matter be listed again after 3 weeks.
May I please your lordship. The IA is for substitution of the legal heir of the deceased petitioner minor.
Who are the respondents?
Respondents are DRDA minor.
3 lordship. I'm for respondent number 3 lordship. Deputy Commissioner.
And what about the other respondents? You have any objection? Or then we'll allow it.
Fine.
Yes, your name please?
S. Rabha minor.
Heard Mr. S. Raval and counsel for the applicant. Also heard Ms. A. Talukdar and G. Assam as well as Ms. N. Bora and a standing counsel for the PNRD department appearing on behalf of the opposite parties. Full stop. This IA has been filed with a prayer to substitute the legal heirs of the writ petitioner, namely
Wife of the writ petitioner minor.
Chanakya Sutradhar, who had expired on
Expired on my lord. 21/2024.
20/01. 2024.
Right.
That is during the pendency of the writ petition, by leaving behind. Where are the people?
Page number 17, my lord, 17.
No, in the writ petition, in the application, where have you named them? Mentioned.
My lord, only the wife has been named, my lord, because the other legal heirs are, my lord, they are major, my lord. And
They are
since we
major.
They are major.
Major or minor?
Major, my lord.
Okay, they are already there.
They are there, my lord. But my lord, since we are asking for the family pension, my lord, in the substitution, my lord.
I have
that's
not
why.
understood. You want to implead whom?
Only the wife.
But impleadment, you have to implead all the legal heirs. Whether they want pension or entitled, that's another matter.
Right.
Your application is defective, Mr. Rava.
My lord, then I may be allowed to file in another one.
On the prayer of Mr. S. Raman and counsel for the applicant, this IA is allowed to be withdrawn with liberty to file afresh after rectifying the defect in the application. Ms. A. Talukdar, Learned G. Assam, and Ms. N. Bora, Learned Standing Counsel, PNRD Assam, present on behalf of the opposite party and do not have any objection to the said prayer. The IA stands disposed of on withdrawal with liberty as well. You have understood the point.
My lord, my
Substitution has to be done correctly.
all the legal heirs.
Yes.
Obliged.
Over.